We do Gadlin, Your Honor.
Yes. For on the record in the matter, the people of the state of Michigan versus Dominic Gadlin, file number is 22-00428. FY council appearance.
Thank you. Good morning, Your Honor. Erin Housefield on behalf of the people.
Fred Blackman on behalf of Mr. Gadlin.
Today's date that was set for a motion hearing. It's on bond, is that what this is about?
Yes, Your Honor.
Was there a motion filed? Don't have it.
I have a copy, Your Honor.
Okay, I do think, I see a motion for bond reduction filed by you, Mr. Blackman.
Yeah. Yes, Your Honor.
Okay, this bond is, it says 7,510%. You're asking for a bond reduction for the reasons that he's a prisoner. And he's gonna receive a flop due to the charge. Is that your reasoning for bond reduction?
Judge, if I might indicate, he has already been flopped because of being arrested for this. He's been sitting in prison. He's actually going before the parole board today. I believe that myself and Ms. Housefield will be able to resolve this matter. We're leaving it on for prelim for next week, but we hope to take care of it during the first part of next week. If he is, the court grants him a PR bond, there's a possibility he would be released on tether with the Department of Corrections. So you'd have Department of Corrections looking, have their eye on him, as well as this court have its eye on him. And I think based upon our resolution of our case, that would be favorable to both parties, that there's no reason for him not to show up and not to resolve this matter because of the potential resolution that we're going to do, Judge. So I'm asking the court at this time to reduce it to a PR.
Oh, and did the people want to respond at all?
Thank you, Your Honor. The bond motion filed by Mr. Blackman would indicate that this charge is causing him a problem because of the flop that he received. Certainly, if he is up for parole and will be granted parole, that will happen regardless of what the bond status is. So for example, if he has a PR bond or if he has a money bond, that's not what the parole board is going to be looking at. So this motion really is less about the flop and the parole status and more about the dollar value of the bond. And certainly I don't see any indication by defense, and when looking at the factors set forth at MCR 6.106F1, I don't know that Mr. Blackman has readily established for this court a valid reason to reduce the bond when we're looking at the potential or the need to return, as well as the safety to the community, whether or not one can post a bond, and the financial aspect of it is only one part of that consideration for the court. And certainly the court is not due to set bond because a person cannot afford it. So with that in mind, Your Honor, I would just ask the court leave the bond as set, since no new factors have been introduced to suggest a valid reason for reducing it.
I am going to say, Mr. Black, and I am struggling with understanding why you believe that the parole board would take into consideration that he has a 7,510% bond. The bond in and of itself, I don't think, is what they're concerned of, and they may be more concerned with the fact that he has a new case, but not necessarily the bond. So your concern is that he can't afford the bond? Is that what the concern is?
Yes, Judge, that's a concern. And also, I don't believe, I would dispute the fact he's a danger to the public. We're talking about a drug case and not a gun or an assaultive case at this particular time. So I don't think he's a risk in the community based upon the restrictions he'll be on.
I think that given the circumstances, he's being charged with one count of controlled substance delivery, manufacture of cocaine, heroin, or another narcotic, facing 20 years and or $25,000. This is an extremely low bond. considering the charge. And it looks like there's at least on this file one bench warrant of failure to appear. I think the bond asset was appropriate. I'm going to deny the motion to amend to a personal recognizance bond.
Thank you, Your Honor.
Thank you. You're all set. Okay, what's this next?
Yeah, let's do Mr. Austin's case. It's a great idea. Jalen Mitchell.
On the record in the matter of the people of the state of Michigan versus Jalen Michael Mitchell, file number 22-02287. Mr. Mitchell, you're not driving, are you? Maybe he's a passenger. Mr. Mitchell, can you hear us?
Yes. No, I'm not driving.
Okay, sounds good. Council appearance, please.
Chris Martin for the people.
Thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Mitchell. He appears with us today via Zoom.
Okay, and Mr. Mitchell, today was the date that was set for probable cause conference. This matter is scheduled for preliminary examination on the 15th at 8:30 in the morning. Are we proceeding to exam on the 15th?
Your Honor, at this point, we would be asking that the matter be left on for exam. We will update the court accordingly next week with our intentions as to whether that will actually run or not. I do have the necessary discovery to proceed to an exam if necessary.
Very good. Any additional matters for the record today then?
Not from the people.
I have nothing further on behalf of Mr. Mitchell, Your Honor. Thank you.
Thank you, Mr. Mitchell. Do you have any questions today?
No, ma'am.
Okay, we'll see you next week in person at the court at 8:30, okay?
Okay, thank you.
You're welcome.
Thank you, Judge.
Okay, thank you. That was Mitchell. Who's next?
For Jessica Long, they wanted to know if they could treat next week exam day as PCC. Mr. Black stuff there.
Where's Jessica Long?
We sent an email to, I think there might be some confusion. We sent an email to the court staff yesterday about it. And we kind of laid out what we were doing, and there were 3 questions at the bottom. One of which was, I don't know, I don't have the email up right now, but I believe Mr. Blackman took it to mean that his client did not need to appeal.
I've not seen or responded to an email indicating someone didn't need it.
I can get Mr. Blackman on the phone.
Did he file something?
We don't have any stuff yet.
Well, then Jessica Long needs to be here. I'm sorry?
Amy Adams, she's set for sentencing tomorrow. Eaton County brought her over today.
They took her back.
Jill would like to know if you wanted to do her.
They took
sentencing
her back.
today.
I think they took her back.
Oh, they took her back.
Yeah, the officer came up.
Yeah, I think they took it back. May I step out and call Mr. Blackman?
No problem.
What do you got?
Good morning, Mr. Feigelson. You're here on Richardson?
Yes, Your Honor.
Okay. Are you ready on that one?
I am, Your Honor. I did speak with him yesterday, so we are all set.
Okay. We're on the record in the matter of the people of the state of Michigan versus Richardson Eliska. This is file number 19-03573 SM. Can I have your appearance, please?
Yes, Your Honor. Good morning, the Assistant Public Defender, Stephen Feigelson. Appearing on behalf of Richardson Elska, who's present on Zoom this afternoon, Your Honor.
Okay, Mr. Eliska, can you hear me? You're muted.
Yes.
Okay, very good. Today's the date that was set for sentencing. We will report the court back on July 21st. You pled guilty to that account 2 of non-sufficient funds. believe there was also a petition for sentencing under HYTA. Did you receive that? There was supposed to be a petition for sentencing under HYTA.
That's correct, Your Honor. I didn't know we were supposed to.
Okay.
We won't be petitioning.
Well, it appears he's eligible, so it's fine. At least that's what the pre-sentence report says. Okay. The pre-sentence report doesn't need any updates, corrections, or deletions.
It does not, Your Honor.
Okay. All right, he's gonna address the court.
Yes, Your Honor. I've had a chance to go through the recommendation by probation with my client yesterday, Your Honor. It does seem appropriate. Your Honor, he is willing to do what is necessary on probation. He is working, Your Honor, does have a part-time job. He's doing all the things necessary to get through probation, Your Honor. He understands the benefit that he is getting if he can do probation without his record. I believe he is willing to do what is necessary on probation. I'd ask that the recommendations be adopted. Thank you.
An opportunity to review the pre-sentence. Thank you. Report and recommendation from probation, as well as the defendant's criminal history, which, other than this, there was nothing there. I think he's a good candidate for probation, and HYTA status will be granted. I'll do a term of 6 months probation. While on probation, we'll have the following conditions: not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to possess alcohol or drugs while on probation. While on probation, and you're going to be required to submit to random preliminary breath tests and/or your analysis and pay the fees associated with it, okay?
Okay.
Not to be at any bars or nightclubs while on probation.
Yeah, I don't do this stuff.
Okay, very good. And you're currently employed, it says. Is that still accurate?
Yes. Damindale nursing home.
Okay, you'll continue your employment. Actually. Actually, I'm not going to require him to be PBT in your analysis at this time. Cases from 2018, I don't find it meaningful. What I prefer to see is continuing his employment. Finish school. Did you finish school, Mr. Oliska?
Oh yeah, I graduated in 2018 from Sexton High School.
Okay, very good. Okay,
Yes.
so I want you to maintain your employment. And I'm going to order you to participate in some economic crime programming. Once you complete that, you can petition the court for early discharge after at least 3 months, okay?
Oh, okay. What is that again?
I'm going to order that you participate in some economic crime counseling, and so the probation department will give you your options for that, okay?
Oh, okay. Thank you.
No problem.
You need to report by tomorrow, Your Honor, probation.
No, he does not need to report by tomorrow. They'll be in contact with him once they get my order into form that he can review and sign. As to fines and costs, there wasn't any restitution, was there? No. I have in my notes that there's no restitution. There's a $30 per month oversight fee that you're responsible for each month that you're on probation. So if you do 6 months, it's $180.
Oh, okay, thank you. Yep, that's good.
Okay, well, I'm not done yet. I am gonna waive the discretionary fines and costs. There are some fines and costs that I have to assess via statute or per statute. One is the crime victim rights fee and the state minimum cost. Crime victim rights is $75, state minimum cost is $50. So that, and if you do the full 6 months of probation, your total would be $305, okay?
Okay, okay.
If you're discharged earlier, you will not need to pay the full 180 on probation, okay?
Oh, okay, okay.
Okay, do you have any questions about your probation or your fines at this time?
Oh, yeah, do I have to pay the fine right now or just?
No, you'll be able to make monthly payments and your probation officer will contact you to go over this order for you to sign it, and they'll go over your monthly payments as well, okay?
Oh, okay, thank you, thank you.
No problem. There's also an advice of rights as to probation and early discharge here. It says that you have been sentenced to a term of probation in the 54A District Court. The probation conditions have been individually tailored and are specific to address your assessed risks and needs. Except for domestic violence, criminal sex crimes, stalking offenses, or an offense where the defense of guilty but mentally ill was asserted, you may be eligible for early discharge from probation. You have the following rights. You have the right to request early discharge from probation once you have completed half the original term ordered by the judge. Your probation officer may, but is not required to, file a notice with the judge once you become eligible for early discharge. The probation officer must send to you and the prosecuting attorney a copy of the notice. The prosecuting attorney has 14 days after receipt of the notice to file written objections to early discharge. You may request an early discharge from probation after meeting the following conditions. A, you have completed all the required probation programming, and B, you have not violated probation in the last 3 months. You must send a copy of your request for probation to your probation officer and the prosecuting attorney. The prosecuting attorney will then have 14 days after receipt of the notice to file a written objection to the early discharge. If a hearing is scheduled, you will have the right to hire or retain an attorney to represent you. You do not have the right to court-appointed counsel if there is a hearing scheduled for your request for early discharge. I have not held any hearings for those at this point. I've been reviewing them based on the written filing. Lastly, you may make your request for early discharge by completing a notice regarding eligibility for early discharge from probation, which is called the MC 512 form. That form is located on the court website. If you have any questions, you can always ask your probation officer, or you can probably reach out to Mr. Feigelson if you can't get an answer that you're looking for, okay?
Okay,
So as I said before, you do 3 months and complete the economic crime, and you're, I think, in a good position to request early discharge, okay?
oh, okay, okay.
Okay, any additional matters for the record today?
No, Your Honor, thank you.
Okay, you're all set, sir. Good luck.
Thank you. Have a nice day.
Take care, sir.
Mr. Blackman,
Yes, Your Honor.
you know where Miss what's her name? Long is?
I talked with her last night and told her that we were going to use next week as a PCC after talking with Mr.
I'm
Martin.
the only one who gets to decide that.
Oh, sorry about that, Judge. I can get her on the phone and get her on Zoom if the court would like.
Yeah, we don't even have an appearance from you yet, do we?
I've sent my appearance in the day. Been a bit, but yes, we've set it in.
There's an appearance, Lindsay said she called for a substitution.
We need a substitution, that's the issue.
Well,
It's in
I
the
think
parent.
my secretary has done a substitution and it's been sent because I checked with all of that before I left this morning. I'm up in Clinton County right now. And I believe it's all been sent.
When did you
I
talk
can
to him?
double check it with my office, but we did it immediately.
Because he said he was here today.
Pardon me?
Okay, well, you did that, you took care of that, you said you checked today?
Yeah, I mean,
Wait.
I checked with my secretary and looked in the file and we had sent it.
Our notes in JIS said that we did not have it. I don't.
Okay,
I
well,
need to know
I can
if
call
they
her
received it.
right after I get off Zoom again and make sure that she's done that, but it looked like from my file, it was done. So I
Okay.
apologize, I don't have my file, I thought after
No,
talking
you
with
don't need to
Mr. Martin.
apologize. I think there was a series of miscommunications. The only person who can decide that we're gonna treat something as a PCC would have to be me
Okay,
on an exam date.
okay.
And I would need to know the circumstances. This was not brought to my attention.
Judge,
until
the
today.
circumstance was well when Chris and I, because I just gotten a discovery and Chris and I were gonna talk. I needed a little bit more time to talk with Chris and talk with a couple witnesses in reference to that. And we thought that having maybe a little bit more time would resolve the matter, that we wouldn't have to have a prelim.
No, I can imagine, and I would imagine if you just substituted on that you would not be prepared to move forward today.
Thank you, thank you. I apologize about miscommunication.
Okay, no worries. Okay, well, I'll note in the file that we'll have to address any timelines next week if necessary.
Okay, and I'll check with my office right now, Your Honor.
Okay. All right, and we'll follow up with the clerk's office because it looks like their last note was actually from the 6th. So
Okay.
If they've
Okay.
received anything since then, they have not updated a note.
Okay, I'll make sure that
Thank
my
you.
secretary, okay, thank you.
And just to confirm, we are proceeding next week as though it's a PCC.
He's gone.
Okay. That's-
I'm gonna note that, yeah, we'll have, we have no choice. But I'll address the timeline if necessary next week.
That's fine. And I don't, obviously, I've never known Fred as one to fight on the timeline stuff. Yeah, well, we've already pulled up witnesses for that, so, okay. Well, yeah, obviously, if there's something that needs to be litigated, we can.
Did you all
Yeah, I'm
respond to
good with
this?
that. And I think I just said, thanks for the, I want to confirm that.
Well, no, there was a question. It says, please advise if it's acceptable to the court for appearances necessary. That requires an affirmative response from somebody.
Wait,
Oh, that's fine. So, you know, I think I was squarely last week. Which project?
Yeah. It's old school. That's a long time.
I was in high school.
Somebody was putting some notes here. and, yeah. Mr. Etheridge?
Yes, Your Honor.
Okay. Which matters he?
He's here on the Latham, Eric Latham, Your Honor.
Okay, looks like they removed him. I see you did leave a note in the chat that you're continuing to preliminary examination. Oh, there's Mr. Latham.
Yes, Your Honor. This time he's rejected the plea offer and would ask the court to leave the matter on for preliminary examination. He would ask the court to consider oral motion for a bond reduction today, if possible. If not, we will address it next week.
Mr. Morris here. We're on the record in the matter of the people of the state of Michigan versus Eric Thomas Latham, file number 22-02016 FY, council appearance.
Chris Martin for the people.
Good morning, Your Honor. Attorney Derek Estridge from the Public Defender's Office, and I represent Mr. Latham. I'm appearing by Zoom, and he's appearing by Polycom from Ingham County Jail.
Okay, today was the date that was set for a probable cause conference. My understanding is that we will be continuing to examination next week. The defense wants to make a motion for a bond reduction. You can do so at this time.
Thank you, Your Honor. May it please the court. Your Honor, I've had the opportunity to discuss bond and bond reduction with Mr. Latham, as well as his attorney in the federal case that he has in Illinois. Just to let the court be aware, it's my understanding that he does have a possible violation pending there, or a violation pending there. So even if the court was so kind as to reduce the bond, I don't know if he would be released or not, but he does request the court consider reducing the bond in this matter. He is under federal supervision. He is being tested by breathalyzer and drug testing as part of that supervision. His federal attorney there, Mr. Bishop, that I spoke with yesterday, said that he had been compliant up until this issue coming up with these charges. He did have a few minor violations, but was for the most part compliant. He does work in the state of Illinois at Plano Molding. It's my understanding that based on what his attorney said, that the federal judge became aware of the warrant, and there was an issue of whether or not he was going to be extradited. The judge gave him the opportunity to come to Michigan and turn himself in, which I believe is what occurred based on what his attorney has told me. His bond is currently set at $150,000 cash surety for these charges. I think that's extremely high for the charges and the risk to the public here. He would ask the court to consider reducing it. I did talk to the prosecutor about this by email yesterday, and there was some indication he would object because of Mr. Latham allegedly making statements that he would flee back to Illinois if he was released on bond, which I think there's some misunderstanding or confusion. His position was that he had said that he wanted to go back, or would go back to Illinois once he got out on bond. I did advise him this morning that that is entirely up to the court whether or not he is allowed to leave the state and come back. He advised me today, if the court does not want him to leave the state and go back to his home in Illinois, that he does have an address here that he could stay at. I could provide the name, address, and phone number to the court. He's willing to abide by any bond conditions the court wants to impose if the court feels that they're necessary in order to ensure any type of safety, or whether or not he'll come back to court, including GPS tether. He advised me he has no mental health or substance abuse issues. Based on this information, Your Honor, he would ask the court to consider reducing the bond to a more reasonable amount that he could likely afford or be able to post. Thank you, Your Honor.
Your Honor, we oppose the reduction at this time. And I do not have any sort of a transcript of notes of the statements made at the time of arraignment. So I don't know that the court even needs to consider that. I think that all the court needs to know is that Mr. Latham is currently on federal supervised release. One of the conditions of that release is that he is not to commit any other crimes, and he's not to leave the state of Illinois. Yet in May, when he was under those terms, a court order, he came to Michigan, left Illinois, went through Indiana, presumably, and committed another crime. And that's what he's here for today. We're set for a week from today. I have real concerns that if he is released, we won't see him again. And so I think it's in the interest of judicial economy and moving this case forward, to leave the bond set where it is, and to proceed to exam next week. And we will, potentially have a resolution at that time.
Oh, thank you. I also do not have the benefit of the transcript or whatever took place at the time of the arraignment, nor do I have a copy of his criminal history, which the arraigning official would have had. I recognize, however, that these are he's charged with what, 2 counts of
Child abuse
child
third,
abuse,
and
third
habitual
charge of
offender
habitual
third.
offender, correct? However, as indicated by the prosecution, we have an extra layer here, which is that he was on federal supervision, and we don't have a valid address of him here. I think there's a risk of his unwillingness to return to court or to follow the court orders. If released on a bond that doesn't, it is not set to properly enforce that. So I don't foresee a bond reduction at this time. Were you gonna add something?
Oh, I just wanted to let the court know that I have, I can provide some of the criminal history of the court, if that'd be helpful to the court's determination.
Well, at this point, I've denied it, so.
And, Your Honor-
Based on, yes.
Your Honor, excuse me, I didn't mean to interrupt. I was just gonna say, I do have an address, a local address that he could stay at. I just didn't put it on the record unless the court wants it.
No, I'm gonna deny the bond. I don't believe that he's gonna stay in Michigan if he's released on bond. So the bond as set is appropriate, bond to reaction is denied. Any additional matters at this time?
Nothing from the people.
No, Your Honor, thank you for considering the motion.
Thank you. You're all set.
Was adjourned. Adjourned.
We'll see you next week, Mr. Latham.
Sir, you got here?
Yeah, sure.
Mr. Latham, you can leave. I'll schedule another polycom with you before the hearing next week.
We're not set till 9:30, right? I'll have to go look and see.
AGM.
That's fine.
Well.
Okay.
That's fine. Well, yeah, we can, it's a quick feeling, so I'm not afraid to just throw it up there and see.
Welton. I guess we're not running anything on Welton. Mr. Etheridge, did you need to speak to your client, Mr. Tall? You're muted.
Yes, Your Honor, if he's present,
He is
I have not-
present.
yes, Your Honor, I have not been able to make contact with you.
Okay, we'll get him on Zoom.
Thank you, Your Honor.
Okay, Mr. Etheridge, I'm putting Mr. Tall in room 2.
Thank you, Your Honor.
Mr. Bulmar Griffin, we're just waiting for your attorney, okay? He just stepped out.
Okay.
Mr. Bigelow and Chris, if you can hear me, Mr. Tall is going to waive the preliminary examination at this time.
Mr. Etheridge, I was talking with Miss Donnelly. I'm not sure what you just said.
Mr. Tall is going to waive the preliminary examination, have the matter bound over to circuit court.
Okay, we can get him and have him brought in. Thank you.
Yep.
Sounds good. We're on the record in the matter of the people of the state of Michigan versus Desmond Paul, file number 22-01383. Council appearance.
Chris Martin for the people.
Good morning, Honor. Attorney Derek Etchers, Office of Public Defender, on behalf of Mr. Tall. I'm appearing by Zoom.
Thank you. And today was the date scheduled for Mr. Tall's probable cause conference. How are we proceeding on this?
People expect an unconditional waiver of the exam, and the people concur in that waiver. There is an offer that Mr. Etheridge asked me to place on the record.
Okay.
The offer at circuit court is for Mr. Tall to plead guilty as charged to CCW. The people consent to HYTA status if Mr. Tall is otherwise eligible.
Mr. Etheridge?
That's an accurate statement of the posture of the case at this time, Your Honor, and I had the opportunity to meet with Mr. Tall and discuss it with him, and that's his decision at this point.
Thank you. And Mr. Tall, you understand that you have a right to have a preliminary examination here in the district court? Okay, you understand that at the time of the examination, you have the right to have the prosecution bring sufficient evidence that would establish that there is probable cause that a crime was committed and sufficient evidence to establish that you committed the crime. You wish to unconditionally waive your examination? Do you wish to unconditionally waive your examination? I mean, unconditional means that you waive it without any stipulations, or you can't come back and have it later. You understand, you wish to waive it, and that waiver is unconditional?
Yes, ma'am.
Anybody make any promises to you to get you to waive your exam? Anybody threatening you to get you to waive your exam? Okay. I'll bind the matter over to the circuit court for a bind over dated September 21st, 2022. We do not need to appear in court on September 21st. That's the date they get the file from this court, okay?
Yeah.
Your next court date will be a pre-trial in the circuit court. Your attorney, Mr. Etheridge, will be made aware of that date, and he'll make efforts to get in contact with you. Now, those efforts before were not successful. You've given me your mom's number, you've given me your girlfriend's number. Did you give Mr. Etheridge a good number for you?
Yes, ma'am.
Okay, and if those numbers change, or if you get your own phone number, he should be the first person that you get it to, okay? Okay, do you have any questions? Bond was set at 3,000 personal recognizance. That will continue. Any additional matters for the record?
Nothing from the people. Thank you.
Your Honor, I will confirm he gave me a local telephone number as well as a local address, and I'll update my file. Nothing further, Your Honor. Thank you.
Thank you. You're all set, sir. Who's next?
The Bulmar Griffin matter, Your Honor.
Okay, we're on the record in the matter of the people of the state of Michigan versus Brian Bulmar Griffin, file number 22-01768. Council appearance.
Chris Martin for people.
And Assistant Public Defender Scott Nichol on behalf of Mr. Bulmar Griffin. I believe is present over Zoom.
He was present. Are you still there, Mr. Bulmar Griffin?
Yes, I am. Sorry.
Okay,
I was trying to
great.
figure my phone out.
No problem. Today's the date that's set for a preliminary examination. How are we proceeding?
Your Honor, that's correct. And I was informed earlier this week that Trooper Luke Schaefer, who's a central witness in this case, is scheduled to be at mandatory Michigan State Police training today and is unavailable to appear. I communicated that to Mr. Nichol. It's people's understanding that we will be stipulating to adjourn the matter to a future date, perhaps 2 to 3 weeks out, so that we can get Mr. Schaefer here.
Is that correct?
That is correct, Your Honor. And I did have a chance to discuss that with Mr. Bulmar Griffin. He understands.
Looks like we've already adjusted the timeline before, so we don't need to worry about that. I will adjourn this matter for a date.
September 29th at 9 a.m.
Does that work?
Of course.
That'll work, Your Honor.
Okay, September 29th at 9 a.m. Did you hear that, Mr. Bulmar Griffin?
Yes, I did, Your Honor.
Excellent. Do you have any questions?
No, I don't.
Any additional matters for the record?
Nothing from the people.
Nothing from the defense, Your Honor. Thank you.
Okay, you're all set. Thank you.
All right, thank you.
Okay, we're on the record in the matter of the people of the state of Michigan versus Khadidra Welton, file number 22-01978. Council appearance.
Good morning, Your Honor. Gage Wakula appearing on behalf of the people, P83866.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson appearing on behalf of Ms. Weldron, who's on Zoom this morning, Your Honor.
Thank you. Ms. Welton, can you hear me?
Yes, I can hear you, Your Honor.
Okay, thank you. Today was the date that was set for preliminary examination. I do have a plea agreement and sentence agreement sheet. It says that the defendant will plead as follows to count 3 of fraud, welfare, failure to inform less than $500. Says defendant also agrees to pay restitution in the amount of $7,467 to the Michigan Department of Health and Human Services. The people or the prosecution intends to or agrees to dismiss count 1 of welfare fraud over 500 and count 2 of welfare fraud, failure to inform $500 or more. That's a complete and accurate recitation of the plea offer, Mr. Feigelson?
Yes, Your Honor, it is.
Okay, and your client wishes to accept that offer?
Yes, she does, Your Honor.
Ms. Welton, you want to accept that offer?
Yes, Your Honor.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, Your Honor.
Thank you. You can put your hand down. Ms. Welton, you have the right to proceed in this matter to a jury trial. You have the right at the time of jury trial to be presumed innocent until proven guilty. You have the right to see, hear, or question any of the witnesses that the prosecution intends to call. You have the right to call your own witnesses at trial or present evidence that you believe would further a defense. You have the right to remain silent at trial and not have silence be used to prove or imply that you're guilty. You also have the right to have the prosecution prove each element of the charges being brought against you, and they have to prove each element beyond a reasonable doubt. In order to accept this plea and plead guilty, you would have to give up each of those rights today. Is that what you want to do?
Yes, Your Honor.
Has there been any threats made to you to get you to give up your rights and plead guilty?
No, Your Honor.
Did anybody promise you anything if you give up your rights and plead guilty?
No, Your Honor.
Are you currently on probation or parole?
No, Your Honor.
And are you pleading guilty to count 3 because you believe you're guilty?
Yes, Your Honor.
You understand that a guilty plea can result in a conviction that you may need to report to your current employer?
Yes, Your Honor.
You also may need to report a conviction on future job applications. You understand that?
Yes, Your Honor.
Okay, and also a conviction could result in having an impact on any immigration status that you may be seeking. Do you understand that?
Yes, Your Honor.
Okay, so I guess there's gonna be an added count 3. Is that what it is? Because I only see 2 counts on.
Yes, Your Honor, that's correct.
Okay, very good. Okay, so as to the added count 3 of fraud, welfare, failure to inform less than $500, how do you plead, ma'am?
Guilty.
What's the maximum penalty? On that?
90 days, Your Honor.
Okay, thank you.
90 days and or $500. This is a misdemeanor.
Thank you. A factual basis, please.
Yes, Your Honor. Ms. Walls, I want to turn your attention back to a couple of years ago, back in 2019. You had applied for some benefits through the state of Michigan, is that correct?
Yes.
And you weren't actually living in Michigan at that time, is that correct?
Correct.
And you intended to defraud and cheat the state out of those welfare benefits, is that correct?
That wasn't my intention, but that is what happened, so correct.
Okay. And what, and you did, and there was, you failed to inform that you were out of state, is that correct?
Correct.
Your Honor, I have no additional questions for this witness.
Any questions for you, Mr. Wakula?
Yes, just very briefly, Your Honor. Ms. Welton, as a result of not reporting the fact you were living in Kentucky, you received benefits in amount less than 500, correct?
Correct.
Okay. And the benefits, these were coming from the Michigan Department of Health and Human Services, which is located here in Lansing, Michigan in Ingham County, correct?
Correct.
Okay. People are satisfied, Your Honor.
The court is also satisfied with the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently.
Judge, I'd ask you to move for immediate since she does live out of state, and given this is really just about repaying money, I'd ask for.
Any objection to immediate sentencing?
No objection from the people, Your Honor.
You can address the court.
Yes, Your Honor, thank you. This woman does live down in Kentucky, Your Honor. She does have employment. She is remorseful for her action and is willing to do the steps necessary to repay the state of Michigan. I would propose a period of probation to monitor a couple of things. One, to make sure that these payments gets made, and or set up a some sort of wage assignment so that this stream of payment can get made to the state to get this taken care of, along with reporting, not non-reporting probation, maybe have to do some sort of class to learn about not to financial crimes. Right? I think that'd be appropriate for that.
Ms. Welton, you're currently employed?
Yes, Your Honor.
I'm gonna sentence you to a term of 12 months non-reporting probation. The purpose of the probation is to monitor the repayments and make sure you're in compliance with that. Restitution will be ordered in the amount of $7,467 payable to the Michigan Department of Health and Human Services. You'll be able to make monthly payments or a payment plan on that, and or a wage assignment. I will have somebody from the probation office get with you to coordinate that, okay?
Okay, thank you, Your
No problem. I'm also going to order that they give you some recommendations for any virtual options, that is for programming. I don't know what options there are that she would be able to participate in virtually, but there should be something. Other than that, there will be no other conditions under this probation, and you won't be required to pay a monthly oversight fee, okay?
Thank you, Your Honor.
Your Honor,
Yes.
I'm sorry, what was the thing about the virtual programs?
Because she's in Kentucky, I want probation to see if they can find, typically you would send someone to do an economic probation program in here, economic crime probation programming, or maybe more recognition. I don't know what the options are for her if she's in Kentucky.
Oh, okay. All right.
Yeah, so I'm gonna have probation look into that and refer her to some programming while she's on this 12 months of non-reporting probation. And they'll also coordinate her repayment in the amount of $7,467. I'll waive discretionary fines and costs. However, there is a $75 crime victim rights fee plus a $50 state minimum cost that must be imposed. You have any questions at this time?
No, Your Honor.
Any additional matters for the record, counsel?
None, Your Honor. Thank you, Your Honor. And thank you as well, Mr. Agee. I'll be in touch soon. If you have any questions, you can call our office.
Okay, Ms. Welton, you're all set for today.
Do we,
Thank you.
Your Honor, do we have a new date set for like a review on the probation or anything?
No, we do not have a date set. What will happen is that probation will contact her to go over my order, and she'll review and sign that. And then they will, if she's not making the payments, then they'll issue a violation.
Okay.
Any other questions?
Nothing from the people, Your Honor.
Okay, you're all set. Thank you.
Thank you, Your Honor.
Thank you.
Thank you.
Good luck, Miss Welton.
Thank you.
I see McKinley Weston, but I do not see anybody from Levine here yet. I see Miss Powell is here. Miss Powell, are you here for Mr. Smith?
I am, Your Honor.
Oh, Mr. Levine is here now. Which matter are you here for?
William Parker, writing on Adam Pfeiffer, prosecutor.
Okay, sounds good. McKinley Weston.
Hello?
Okay, can you hear me, Mr. Weston?
Yes.
Okay, we're on the record in the matter of Rawl LLC versus McKinley Weston and file number 22-01667 LT. Can I have your appearance, counsel?
Thank you, Your Honor. Attorney Brandon Levine on behalf of Rao LLC.
Okay, today was the date set or reset for a motion to stop eviction. This matter was originally scheduled for July 20th. Mr. McKinley Weston failed to appear. So we set it again for hearing on the 3rd of August, and Mr. Weston again failed to appear, so a default judgment looks like was issued.
That's correct. Your Honor.
Mr. Weston has filed a motion to stop eviction. It says Section 8 paid while red tagged. Sarah paid $9,520 and rent $760 6 months, but paid something 4 years. I'm not sure. Mr. Weston, did I accurately read your motion? Mr. Levine, did you want to respond to the motion? It seems to feel like the rent's been paid.
Yes, Your Honor. Recently, as this morning, I went ahead and checked with the client, and he confirms that they have not received, I guess I would say disconfirmed that any payment was received. We're going on 9 to 10 months. As an update, there are some other things that are happening. Apparently, the police just raided the place less than a week ago. I don't want to pollute this with things that are extrinsic to the question, but I think the police was going after defendant for certain. I'll just be tactful and call it criminal matters involving a minor. And so he fled, and then windows were broken, and so the place has been vacant for a while, at least since the past, I don't know, week or so. And so the things have been in repair of those windows right now. There's like boards up there until they can repair all the windows. But that, again, no payment has been received. We're going on 9 to 10 months now.
Okay, Mr. Weston, this eviction looks like it was filed
Yeah. But saying
in October. Let's see here. When was this? Oh, it was filed in May of 2022. You did attach, it looks like, an email
from Sarah.
that came from Lakeshore Legal Aid, it appears, but it sounds like you had a decision date back in September of 2021 for rental assistance for $7,240 and future rent $2,280 is what this says.
Right. It's our understanding that that covered rent that predated the most recent stint that for which he hasn't made a payment, according to my client.
Yes, Your Honor,
Yeah,
that is
yeah, but what I have here, Mr. Weston, you also attached a letter from Ms. Pereira. You must have had a previous eviction, and because of that payment, that eviction was dismissed. Is that correct?
yes.
Okay, did you pay rent after that?
The reason that the rent was not to be paid after that up to now is because if you look at the attached form about the Section 8, there was no previous month that I owed rent. It was only the 2 months when they stopped paying in August of that year.
I don't know what you're talking about from Section 8. I don't have anything from Section 8, I don't think. Is that what you mean, the MISHDA form you're talking about?
There should be one from Sarah and then one from Mr. via Section 8. That would say the last payment was August.
The only thing that I have is what was forwarded dated April 27, 2022. I'm saying that you had financial assistance submitted on July 6, 2021, decision date of September 17, 2021. It said payment would be made within 2 weeks. That at the time you were in arrears of $7,240, and that they were approving to pay future rent in the amount of $2,280. I don't think that it doesn't sound like the plaintiff is disputing that they received that money. They're saying that that doesn't absolve you from your future rents beyond that, and that you haven't paid any money since then. This eviction was not even filed until May of 2022, so it would have been several months after they would have received this money, which I think they got this money probably back in October of last year.
That's correct.
Yes, Your Honor, but as I'm explaining, there was the 7,000 back rent was put wrong because Section 8 stopped paying in August of last year. They received.
Well, if it was put wrong, then you that should have been addressed in the other file. That has nothing to do with this file, and I'm not addressing it. You had an attorney, you had representation through legal services, and she seems to believe it was handled correctly as well. And that's in the letter that you attached.
I thought I attached 2 letters.
I only have the one letter that you attached from Ms. Pereira. And she said you sought legal representation from our office through our eviction diversion program. A dismissal was entered in your case, and is attached to this file. And that was you didn't attach you did not attach the dismissal on that one, but we have a letter where she forwarded this, appears to you.
So I'm just missing the Section 8 paperwork that you guys needed then?
Yeah, if you have some Section 8 paperwork, also, I would like to see a copy of this dismissal. I'm assuming you must have had another dismissal or another
Yes.
file that was dismissed, because it wasn't this one.
Yes, it was through them. They dismissed it. I didn't know anything about that. I thought this was already dismissed. That's why I disputed it.
Yeah, what, did he have another eviction, Mr. Levine? I'm confused as to why he has this email that's dated for June 23rd, 2022, stating
Yes.
that the case was dismissed.
Yeah, absolutely, Your Honor. So they had another counsel that was going to come on, and for whatever misinformation, I think it may have been a misstate. So we just refiled, or the client refiled, and then I got on the case since. But no payment has been made since. So not to sort of make it too streamlined, but at the end of the day, there's no payments that have made since. It seems like it's a little bit of deliberate obfuscating to try to manipulate the context to make it look like a predated payment from a prior eviction somehow applies to this, and then possibly looking to exploit a recent dismissal that has to do with some misinformation with another counsel. But nonetheless, we refiled. The matter's outstanding. Nothing's been paid since. And so, you know.
Okay, and I don't have any record that would demonstrate that the files that you attached to your motion, sir, does not demonstrate any recent payment. States here the payments were from September 2021, and that you were already in the rear September 2021 of $7,240. We're already a year from now. So
Understand that, and I
so
thought
your
that.
motion is denied, sir.
Okay, so what does that mean?
That means you filed a motion to stop the eviction, and you provided those two documents to support why you believe you should not have been evicted. Aside from the fact that you had a default and you did not appear, I don't believe you provide justifiable reason to stop the eviction, because this paperwork does not demonstrate that you have that you had SARA payments for the rents from this year. Those were SARA payments from last year.
Okay. So I understand what you're saying.
So your motion to stop eviction is denied. Mr. Levine, can you give me an order?
Yes, Your Honor, we'll do that. We'll have it brought shortly to the court. Thank you, Your Honor.
Thank you. Okay, you're all set, Mr. Weston.
Okay, is this like the last court date, or how does that work? I'm confused.
Yes, this was only a special court date because you filed a motion. You had two previous court dates on this, which would have been your time for a pretrial and a hearing that you failed to appear on. And so there was actually a default judgment entered against you, which is how Mr. Levine's client was able to request a writ of execution to move forward with the eviction. It wasn't until after you got notice of that you filed your motion to stop the eviction, attaching the documents stating that the property or SARA paid a certain amount. But those, and SARA did pay, it looks like $9,520, but that was from your past due from 2021. It's now September 2022, and you've not provided proof that any other payments have been made since then.
So what happened? When can they put my stuff up?
They've already have a writ date, so once they get me the order,
So
and it enters, they can request their execution.
when can I send, why can't I send the Section 8 paperwork that says I don't owe them nothing from last year? Because Section 8 was paying it all last year. They've been paying it for 3 years.
You can, if you have such paperwork, you can file it with the court and file a new motion to stop the eviction, and I'll review it.
Okay, and how long do I have to do that? Because I don't get paid until tomorrow.
You're gonna want to do that immediately, sir. We're talking about an eviction. You don't want to wait. This is a matter that was set for hearing in July. It's September.
Is there a way I can email it to someone? Because I have it right now
You
with.
absolutely can email it if you have it. And you can send it to Judge Simmons Courtroom at lansingmi.gov.
Okay, thank you.
Okay, and so if we receive that and I feel that it's worth another hearing, we'll reset it and you'll get a new notice for hearing. Okay,
Okay.
all right, you're all set then, sir.
Thank you, Your Honor. Thank you, Your Honor.
Thank you.
Thank you.
Ms. Powell. Ashley Hill has failed to appear. Looks like there was an incomplete proof of service for Ashley Hill.
I did look at that one, Your Honor, and it appeared on the bottom, the certificate of mailing has the date that the document was mailed.
No date of service listed and not signed by party providing service.
Yeah, I believe our staff, she signed the certificate of mailing at the bottom in error, but that was the date it was mailed. This was told to me this morning.
Is that who Michelle Sands is?
Yes, she works at our office.
So it's served on 8/16/22. Okay, you can issue a bench warrant on this one.
Okay, what amount, Your Honor?
Bond in the amount of $300.
Okay, we will do.
Okay, thank you on that one. And then we have Asia Moss. Looks like it's the same thing.
Yeah.
Signed where it says certificate of mailing.
Yep, I'll inform her of the proper way to do it from here on out. I apologize, Your Honor.
Okay, how much is owed on this one?
This one has an outstanding balance of $13,886.45.
Okay, you can do a bond in the amount of $1,300.
Thank you, Your Honor. We will submit that to the court.
Thank you, you're all set.
Have a good morning.
Same to you. Okay, Mr. Pfeiffer has arrived. Parker is in custody. And we're running more too, is that correct? Mr.
It looks as though Mr. Moore is going to waive his right to a preliminary exam.
Oh, he's still thinking about it.
His attorney informed me that he's going to waive, but his attorney has to go feed the park.
Oh, okay, sounds good.
But we can handle the waiver for Mr. Pfeiffer's case and then move on to Mr. Moore's case.
Well, oh, you don't have it here. Is that what the law wants? Not sure where. Okay. We are on the record in the matter of the people of the state of Michigan versus William Parker, file number 22-02086. Council appearance.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Gidget James on behalf of William Parker, who is in custody, present at defense table and standing to my right.
Okay, how are you, Mr. Parker? I'm sorry?
I'm good now.
I'm doing well, thank you. Today was the date that was set for preliminary examination. My understanding is that there's going to be an unconditional waiver. Is that correct?
That's correct, Your Honor.
That's correct, Your Honor.
Is there an offer?
Not this time, Your Honor. He has two other files up and another file up with Judge Jamo Circuit Court. So once there's up Circuit Court, there will be a global resolution worked out.
Okay. Mr. Parker, do you understand that you have the right to have a preliminary examination in the district court?
Yes.
You understand at the time of examination, you have the right to have the prosecution put on sufficient evidence to establish if there's probable cause that a crime was committed and probable cause to charge you with the crime. You understand that?
Yes.
You wish to waive that examination today? Do you wish to waive it unconditionally, meaning you can't come back later and say, you know what, I changed my mind, I want my exam?
Yes.
Okay. Is anybody promising you anything to get you to waive your exam?
No.
Did anybody threaten you to get you to waive your exam? You're waiving it freely and voluntarily?
Yes.
Okay. The bind over date is going to be September 21st. You do not need to appear in court on that date, though. That's just the date that they get the file from this court, okay? Your next court date will be in circuit court, but it'll be a pre-trial. Ms. James will be made aware of that date and she'll be in contact with you, okay? Bond was set at 25,000, 10%. Any reason to address bond today?
Not from the people, Your Honor.
Not from defense, Your Honor.
Okay, bond will continue. You're all set.
Thank you, Your Honor.
Thank you. Mr. Rossi is back. You see Mr. Moore?
Yeah, he's in the hall.
We're ready.
More, come on in. He's gonna wait.
Oh, we're on the record in the matter of the people of the state of Michigan versus Emil Moore, file number 22-00629 FY, council appearance.
Just Martin for the people. Jeffrey Roth on behalf of Bill Moore, who's standing to my right.
Thank you. And Mr. Moore, today was the date that was set for preliminary examination on this file. We have one count of weapons, firearm, felon, or possession by felon. My understanding is that you wish to unconditionally waive your examination. Is that correct? Okay, are the people waiving their exam?
That's correct, Your Honor.
Okay. Was there an offer?
Your Honor, not a firm offer at this time, but we anticipate that there will be a reduced charge offered in circuit court.
Okay, so Mr. Moore, do you understand that you have the right to have an examination here in the district court on this file? At the time of the examination, you have the right to have the prosecution put forth sufficient evidence to establish their burden that there is sufficient probable cause that a crime was committed and probable cause sufficient to charge you as the defendant in the crime. You understand that? And do you wish to waive that examination unconditionally today? Is anybody threatening you to get you to waive it? Nobody promising you anything to get you to waive it? You're waiving it freely and voluntarily? We'll bind the matter over to the circuit court for a bind over date of September 21st. You do not need to appear in court on September 21st. It's the date they get the file from this court, okay? The next court date on this file will be in circuit court. It'll be a quick trial. Mr. Rothstein will be made aware of that, okay? If you have any questions? Okay, we'll get you this paperwork to sign. A bond was set at 1,500 personal recognizance that will continue. Any additional matters for the record?
Nothing with the people. Nothing, Your Honor. Thank you.
I think that's all we have today.
It's all for the criminal docket.
Well, the civil docket's done too. so.